Hello, everyone. I'm Major Garrett in Washington. Let me welcome you to the Takeout. We did not expect to start tonight with Article 92 of the Uniform Code of Military Justice. We are, because a debate, if you can call it that, broke out today over what it means and calls by the President of the United States for charges of treason against 6 Democratic members of Congress. Treason, as you might know, is punishable by death. President Trump amplified a Truth Social post calling for the lawmakers' death by hanging. This, ladies and gentlemen, is where we are. Article 92 of the Uniform Code of Military Justice says service personnel must obey lawful orders. Failure to obey lawful orders can result in court-martial. There is, however, an important qualifier. Military personnel have a duty to disobey a manifestly illegal order.
If the rule of law still matters to you, take a second. Subscribe, like, and share this video. A judge just told Donald Trump that the next violation won't end in another fine. It will end in custody, not symbolic, not theoretical, actual restraint. And that warning alone disrupts decades of political gravity. We're no longer debating rhetoric. We're confronting the possibility of a former and now sitting president being jailed for contempt of court. That's not a headline. It's an institutional rupture.
Well, the judge overseeing former President Trump's case issued a warning to the former president. Now, the justice there, according to the New York Times, telling Trump's lawyers to speak to Trump and those in his circle and tell them to, quote, refrain from making statements that are likely to incite violence or civil unrest. The judge, however, stopped short of issuing a gag order. But will Trump be able to contain himself? To discuss, I want to bring in Yahoo Finance senior columnist Rick Newman. So, Rick, let's talk about this, because what we heard from Trump after that last night in a speech from Florida, he really seemed to resort to his old habits. So it doesn't seem like he's going to be able to really hold back much.
Oh, he railed against everybody last night, not just the prosecutors who have now filed these short charges in New York and the judge overseeing the case. He went after prosecutors who haven't even filed any charges against him yet, including the Fulton County District Attorney in Georgia and the federal special prosecutor who's looking into obstruction of justice.
Sure. Judge Juan Merchan imposed a narrow gag order during the Manhattan criminal trial. Narrow, targeted, specific. It did not silence Trump's campaign. It did not bar him from proclaiming innocence. It restricted one behavior, attacking jurors, witnesses, prosecutors, and court staff in ways that could intimidate or endanger them. A procedural shield to protect due process. Trump violated it almost immediately. Posts targeting witnesses, comments about jurors, public statements aimed at undermining individuals participating in the trial. Each time, the court responded with contempt findings and $1,000 fines, one after another. 10 violations, 10 findings, 10 reminders that court orders are not suggestions. And yet the behavior continued. Here's where it shifts from courtroom management to constitutional tension. Fines are coercive tools. They are designed to compel compliance, but fines only work if the defendant fears them. For Trump, $1,000 is not punishment. It is background noise. The deterrent failed, so the judge escalated. On May 6th, after the 10th violation, Merchan made it explicit. Continued defiance may require incarceration. Read that again carefully. A sitting judge, in open court, signaling that jail is now on the table for a former president who refuses to comply. That is not routine. That is a system reaching the edge of its patience. And here's the destabilizing question. What happens when a man who built his political identity on defiance is told that defiance equals a jail cell? Because this is not just about compliance, it is about hierarchy. Trump's brand is dominance. Submission to judicial authority contradicts the mythology. Backing down looks weak. Obedience looks like surrender. But defiance now carries a concrete consequence. Criminal contempt is not symbolic. Under 18 U.S.C. Par 401 and equivalent state authority, courts possess inherent power to punish behavior that obstructs the administration of justice. Not later, not after trial, immediately. A judge can order confinement to preserve the integrity of proceedings. That is not extraordinary power. It is foundational power. Without it, courts are theater. And Merchan's warning signals something more dangerous than a single sanction. It signals that at least one judge is willing to treat Trump as an ordinary defendant when he acts like one. That shatters the protective ambiguity Trump has long relied on. For years, the pattern was delay, appeal, attack, settle, repeat, consequences blurred, deadlines stretched, accountability diffused. But contempt findings accumulate like structural stress fractures. 10 violations are not accidents, they are a pattern. And patterns matter, because this is not isolated to Manhattan. Other judges are watching. Federal courts handling January 6th related charges. Courts overseeing classified documents litigation. State courts processing parallel indictments. They are observing how far a trial judge will go to enforce authority. If incarceration becomes precedent, the psychological landscape changes. Now consider the escalation. A judge reluctant to jail a defendant during trial must weigh competing constitutional interests. The defendant's Sixth Amendment right to participate in his defense versus the court's obligation to protect jurors and witnesses. Jail is disruptive. It complicates logistics. It creates appellate questions. Yet the judge said it anyway. That suggests something critical. The risk posed by continued violations is approaching the risk posed by incarceration. When a judge signals that confinement may be less destabilizing than ongoing intimidation, the scale has tipped. And here is where the tension tightens further. Trump is now president again. If incarceration were ordered, enforcement becomes a constitutional labyrinth. The Secret Service has a statutory duty to protect him. You cannot simply place a president in a standard detention facility. Security, separation, executive function, every variable explodes simultaneously. Modified custody, secured location, house arrest. None of these options have modern precedent for a sitting president held in contempt during criminal proceedings. We are in uncharted territory. But pause for a second. The logistical complexity does not erase judicial authority. It complicates execution, not legitimacy. A court order remains a court order, and if it is ignored, we cross from legal conflict into separation of powers confrontation. That is not dramatic language. That is structural reality. The broader pattern is unmistakable. Attack the prosecutor, attack the judge, attack the jurors. Frame the process as illegitimate. Push boundaries until enforcement looks political. Then claim persecution when enforcement arrives. That is not random behavior. That is an authoritarian playbook. Discredit institutions before they discipline you. And yet, every contempt finding undercuts that narrative, because each finding is a formal judicial determination that a specific order was violated, not politically, legally, factually, on the record, 10 times. Ask yourself, if any other defendant accumulated 10 contempt findings in an ongoing criminal trial, would jail even be a debate? Or would it already be reality? This is where the constitutional stakes widen. Equal application of the law is not aspirational. It is operational. If high office immunizes defiance, the judiciary weakens. If the judiciary weakens, enforcement collapses. And if enforcement collapses, the Constitution becomes decorative. Merchant's warning draws a line, not a rhetorical line, an enforcement line. But here's the psychological trap tightening around Trump himself. If he complies fully, he signals that the court controls him. If he violates again, he risks confinement. Either choice damages the image he has cultivated. This is no longer about messaging. It is about control. And control is the central theme of this entire saga. Who controls the narrative? Who controls the courtroom? Who controls the boundaries of executive power? Because if a president can openly defy judicial orders without consequence, the separation of powers becomes fiction. Conversely, if a court orders confinement and the executive branch resists enforcement, we are staring at constitutional crisis in its rawest form. Notice how quickly the stakes escalate. What began as a gag order to protect witnesses now touches the architecture of American governance. And that escalation is not hypothetical. It is triggered by a single future act. One more violation, one more post, one more attack, one more calculated push. The judge has effectively said, the next move is yours. That transforms this into a test of institutional resolve, not just Trump's resolve, the judiciary's, the executives, the public's tolerance for brinkmanship. Because make no mistake, incarcerating a sitting president, even briefly, would detonate political shockwaves. Markets react. Allies question stability. Opponents exploit optics. The imagery alone would be historic. And yet, the alternative, allowing repeated defiance to continue unchecked, signals that presidential power supersedes courtroom authority. That is a far deeper rupture. This is what constitutional stress looks like. It does not arrive with tanks. It arrives with procedural disputes that escalate into structural confrontations. The next violation, if it happens, will not just be a breach of a gag order. It will be a referendum on whether judicial authority can bind executive power in real time. And here's the final destabilizing realization. The system has already bent to accommodate extraordinary circumstances. Fines instead of jail, warnings instead of confinement, patience instead of immediate escalation. The elasticity is nearly exhausted. When elasticity runs out, institutions snap back. If you believe accountability matters, if you understand that the rule of law survives only when enforced equally, then do not passively observe this moment. Subscribe, like, share this video. Push this analysis into every corner where misinformation thrives, because constitutional crises do not announce themselves with sirens. They unfold through ignored warnings. A judge has issued one. The next move may redefine the balance of power in the United States.